They won't give me a copy of the will. Hi, I'm Darren Findling of the Probate Pro, and following the death of an individual, a common narrative that we hear is that a family member will not produce the will of the person that died, whether it's the stepmother, the sibling, or someone else. They get frustrated because they're fearful that they may be excluded from the distribution, or that there may be simply bad acts going on, a lack of transparency, or bad actions by the person who is controlling the will. In Michigan, there's a statute that provides within reasonable promptness following the person's death, if you're in possession of an original will, you have to produce it to the probate court. That doesn't mean you have to open a probate estate, but you must deliver it to the probate court and they store the will there. And following the death of an individual, if the will is at the probate court, you can produce a death certificate to view the will. Now, to compel somebody to do that, to force them and force their hand to deliver the will to the probate court if they're not going to, or to share it with you. Of course, if you have failed by asking them to do so, then you can get a copy of the will by typically filing a petition for probate. The petition would be filed indicating that you believe there may be a will, but it hasn't been produced. When notice is provided to the interested parties and a court hearing ultimately occurs, the people who have the will typically have an interest in producing it. And if they don't, you can ask the court for an order for them to produce the will. Now, that doesn't necessarily mean you're going to be included in the will, but it does give you an opportunity to understand the contents of the will, whether you're the nominated personal representative, and of course, whether you're going to be inheriting anything. People often have this misconception that if they have the will, that they get to handle the administration without court involvement. And that's actually the opposite. The opposite is actually true, in that the will is the guidebook to get through probate. It is how the probate will be administered, who is nominated to be the personal representative, and how the distributions are set to be distributed. But probate court is required when there's a will. Now, there are times you can avoid probate if the estate is quite small, but in most contexts, if there's a will, there's going to be a need for probate. And probate is a public record. It's a public forum, meaning you can go to the probate court and examine the contents of a probate file. You can examine the contents of the pleadings as well as the will. So if somebody dies and a family member fails to turn over the will, first ask. And if they don't respond, hire a lawyer, a skilled, competent probate practitioner to compel them to have that will produced so that you can know whether you're properly included or excluded. If you've got questions about probate, visit us at theprobatepro.com or call us at 1-833-PROBATE.